Hello, everybody. This is JC Brando talking here with the Office of the Attorney Margaret W. Wong and Associates. And today we're going to have an awesome show with the attorney Francis Fungsan, who has a lot of experience working in the immigration field. And he's one of the doctrinaries in the office that works writing down the process of how you can do stuff, but also going to court, also doing the applications for a lot of people. He has been awarded several times, and today we have the pleasure to have him here with us in the show. So let's welcome the attorney Francis Fungsang. Good afternoon. How are you doing today?
I'm good. I'm glad to be here.
Thank you so much, attorney. And well, today we have some stuff going on, especially with the TPS for Venezuelans. So what should we know about this new TPS? What are there new rules? Are there new what do you call them? Well, directions to do this kind of application. What do we need to know about this?
All right. So the exciting news about TPS in Venezuela is that the president has announced two things. Number one, that TPS for Venezuela has been extended, and that TPS for Venezuela has been redesignated. Now, what does that mean? That means that the old TPS program for Venezuela, you had to be here since 2021, and you had to register for TPS within a certain period of time. If you were part of that group and you were approved, or your case is still pending, that program has been extended until 2025, okay? So the re-registration period, if you already have TPS, is from January 2024 until March 2024. Make sure you re-register to extend your TPS during those 60 days. Okay, don't do it now. Wait until January 2024. If your first TPS application is still pending on January of 2024, you do not have to re-register, just wait. That's the first part. The second part is the redesignation. That means that if you have not applied for TPS before, and you have been in the United States since July 31st of this year, 2023, then you are allowed to apply for TPS for the first time starting now, starting this week. So you just want to make sure you submit your TPS application as quickly as possible with proof that you've been in the United States since July 31st of this year.
Okay, thank you very much, Attorney Francis. And what about this discussion that is going on about the work permit for 5 years or for 3 years? What kind of work permit is it?
Okay, so in the past, immigration has approved work permits for 1 year or 2 years, depending on the category, and then you have to renew that work permit before it expires. Now, unfortunately, the Immigration Service has been slowing down in their work permit processing. It's taking a long time to get the work permits approved. And so during the pandemic, a couple of years ago, they decided, well, in certain categories, if you file the work permit extension on time, then you can use that receipt for an extra 180 days or 540 days to give immigration time to approve the extended work permit. Well, now that's slowing down as well. So the new rule starting last week is if you apply for the work permit in certain categories, that means you are approved for asylum, you are applying for asylum, you are applying for 10-year cancellation, or you're applying for permanent residency, that means I-485. All of these categories, immigration will start approving work permits for 5 years so that you don't have to keep filing extensions every year or every other year.
Okay, thank you very much, Attorney Francis, for this information. And well, we have a question coming in. So if you have any questions, please feel free to write them down, and the Attorney Francis Funsan will answer your question. This question says, "Hi, I have been waiting for I-130. My husband filed for me a year ago, but until now I don't have a receipt or any notice from immigration. What could be going on?"
Okay. When you file paperwork, an application with immigration, you should receive a receipt notice within 1 to 2 weeks in the mail. That has your case number on it, and it confirms that immigration has received your filing fees, the money you paid. Now, if you filed online through a My USCIS account, then you have to log into your account to download that receipt. If you filed by mail, then your receipt should have come in by mail. If you received no receipt, then I suggest you contact the USCIS either through their website or by phone. Have your husband call because he is the petitioner and say that he filed, but he never received the receipt notice in the mail. They'll ask for his name, his date of birth, his address, and then they can check the system to see if there was an actual application that was received. Maybe immigration never received it or it got lost in the mail.
Okay, thank you very much, Attorney Francis. And if you need more information, please don't forget that you can call the phone number 216-279-3984. 216-279-3984 is the phone number that you need to call in order to talk to one of the attorneys in the law firm of Margaret W. Wong and Associates. Good morning. I entered on a B2 visa and an employer wants to hire me. My question is, how long would it take for a visa to be granted in my favor?
Okay. Now, the important thing is here, you entered on a B2 visa. Usually, you would be allowed to stay for up to 6 months. So if you want to stay in the United States beyond that 6 months, you have to file some application within that 6-month period before the expiration date. Okay. The problem is, a lot of times, these work-based temporary visas, you might not be eligible to apply right now. If you're talking about the employer sponsoring you for the green card, that could take 1.5 to 2 years, much longer than the 6 months you're allowed to stay for the temporary status. So the first question we have to ask is, what type of work visa are you eligible for? Because that depends on what your education background is, what your experience is, what type of business the employer has, what type of job you are being offered, okay, and what country you are from. We have to answer all of these questions before we decide what type of visa are you eligible for. For example, the most common type of work visa is the H-1B. But if you've never had the H-1B before, you have to go through a lottery process, and the next lottery is held March of 2024. And if you get selected, you can't start working until October of 2024, which means that that's way beyond the 6 months you're allowed to stay on a B2 visitor visa. Okay, so you have to figure something else out about how to stay in the United States, or you might have to leave the United States until the H-1B is approved, apply for the H-1B visa at the US Embassy, and then re-enter the United States.
Thank you very much, Attorney Francis. We are getting some interesting questions today. And this question says, I entered on ESTA visa. My daughter filed for me, but I had to overstay because my stay was for only 90 days. I am from Italy.
Okay, if your daughter is a US citizen and over the age of 21, then your daughter can sponsor you, petition you for the green card, even if you came into the United States on ESTA and even if you overstayed. That's because your daughter is what's called an immediate relative. So you should file the I-130 and the I-485 together, and the Immigration Service should approve the green card, assuming there are no other problems.
Okay, thank you so much, Attorney Francis. And we have another question here that is going to be very interesting. My computer is a bit slow today, so that's why you see some delay. This question says, I have a court pending for 2024. It's a removal proceeding because I entered through the border. They let me in, but they put me in removal proceedings. Now I am Venezuelan. I would like to file for TPS, but would this be a problem? And what should I do with that court that is going to go on next year, 2024?
Okay.
Should I send a letter or something?
Okay, assuming you were in the United States as of July 31st of 2023, this year, that means you are eligible to apply for TPS, even you have an ongoing deportation or removal case. So you should definitely apply for TPS right now with the form I-821 with immigration, okay? On the application form for TPS, it'll ask, have you ever been in removal or deportation proceedings? Make sure you check yes, okay? Now, once you apply for TPS, you'll get a receipt notice. Yeah, it'll have your case number. For your court date in 2024, should notify the judge that you've applied for TPS. And the judge should either continue your removal proceedings, that means delay it, or maybe the government attorney and the judge will agree to close the deportation case. That means terminate the case so you no longer have a deportation case, okay? If you have an immigration attorney, then you should contact the attorney to apply for TPS right away. Once you have the receipt, that attorney can get in touch with the government attorney for your 2024 hearing to discuss about closing the deportation case.
Okay, sounds interesting. So thank you so much, Attorney Francis, for this answer. Don't forget, you can call. The phone number is 216-279-3984. 216-279-3984 is the phone number you need to call in order to talk to one of the attorneys or to make an appointment with the attorneys here in the law firm of Margaret W. Wong. We have a lot of questions coming in right now. And this next question says, how do I prove that I have been present in the United States for the last 3 years?
Okay, so to prove, so I'm not sure why you need to prove you've been in the United States the past 3 years, but the question is, how do you prove it? Okay, so it could be tax returns if you file taxes. It could be other financial documents like bank statements or pay stubs to show you've been working. Could be insurance documents if you had car insurance or other types of insurance. It could be medical records if you had to see a doctor that has your name and the date. Okay? It could be housing documentation if you signed a lease, or if you bought a house, or if you have gas bills, electric bills, sewer bills, water bills with your name on it and the address and the date. Okay. Now, if you were living someplace but you didn't have a signed lease, maybe you can get a letter from the landlord confirming how long you've been living there. Okay. Anything with your name and the date, or your name and the date and the address, will help prove you've been physically in the United States.
Okay, thank you very much, Attorney Francis. And well, don't forget that the offices of the Attorney Margaret W. Wong Associates are in the city of Atlanta, Chicago, Cleveland, Columbus, in the city of Nashville, New York, and Raleigh, North Carolina. And the phone number is just one. You just need to call that phone number and they will be able to take care of your case. 216-279-3984, 216-279-3984. This question says, I was beat up by my partner. I left him and came to live in other state. He was arrested by the police. Can I file for EU visa, and do I need to move back to the state where I was?
Okay, so EU visas are for victims of certain crimes. Now, felonious assault is one of those qualifying crimes. And if the police are willing to help you with the U visa paperwork, that means that the police department has to be willing to sign the form called a Supplement B, the I-918 Supplement B, in order for you to apply for the U visa. If the police department is willing to sign that form, then yes, you can apply for the U visa because you are a victim of a qualifying crime. You were harmed, okay? Now, the police usually will not agree to sign if you do not agree to help them in their investigation. You have to show that you've been willing to assist the police in their investigation. So if they ask you to help testify or to talk to them about the case and you just ignore them, they probably will not agree to sign the paperwork. So you should contact the police department about the case, tell them about the U visa, ask if they're willing to sign. And if they say, well, are you willing to testify for this prosecution? You should say yes if the U visa is something you want to do. But the question is, do you have to move back to the previous place? You do not have to move there. We have to be willing to assist the police if they ask.
Okay, thank you very much, Attorney Francis. And also, I think there are several situations or cases that could be contradictory, or what happens if this person moved? Let's say this person lives in Georgia and moves to Florida, just trying to go away from this other person. If there is a court hearing, do this person need to come to Georgia to show up in the courtroom?
If the police department or the prosecutor wants you to help testify against your partner for that case, and you want to try to pursue this U visa, then you would have to go back to the courtroom in Georgia to testify, because otherwise the police or the prosecutor might not agree to sign that U visa form.
Okay, that's interesting.
But if they tell you, oh, you don't have to be there, we've got enough evidence on our own, then maybe they're willing to sign it without you having to go there.
Okay, thank you very much, Attorney Francis. Don't forget the phone number is 216-279-3984, 216-279-3984. What other requirements for to file for EB5 visa? Thank you.
All right, so the EB5 is for immigrant investors. That means you invest a certain amount of money into a US business, and that money is used to create at least 10 US jobs. Then you can apply for a green card based on that investment. Okay, so what are the requirements? There's two different types of EB5 investments. There's what's called direct investment, and then there's what's called regional center investment. Direct investment means you invest directly into a US business. It could be a restaurant, it could be a motel, it could be a startup business, it could be a store. And then you are responsible for making sure that enough people are hired, at least 10 US workers are hired using your investment funds, okay? The regional center investment is, regional centers are entities that are pre-approved by the Immigration Service. That means that they collect projects. Maybe it's a real estate project, maybe it's some sort of construction, maybe it's another business. They will gather investors, combine the money for that specific project, and then your obligation is just to invest the money, and then they will take care of the job creation information. You are just waiting for the green card to be approved, okay? Now, whichever one you choose, the investment amount, the minimum is $800,000 US if the business is located in what's called a targeted employment area, or a TEA. That's a high unemployment area. If the business is not located in a TEA, then you have to invest $1,050,000 US. Okay, so making the minimum amount of investment, there's a plan to create at least 10 US jobs. And then the question is, when can I get my green card? If you are physically in the United States, and you are eligible to apply right here, then it's possible you can file the EB5 petition and the I-485 green card application at the same time and stay in the United States to wait for the green card. If you are overseas, you have to file the EB5 petition first. That has to be approved. Then the file is transferred to the National Visa Center, and then you will be scheduled for an interview at the US Embassy in your home country to get the green card. Okay, so these are the different steps to go through the EB5 process.
Okay, thank you so much. And well, this person was adding here that they build fancy personalized electric cars.
Okay, so if you started your own business, that means that you have to show that you have invested the minimum amount, whether it's 800,000 or 1,050,000. So that means that you have to show that it was your personal funds that you put into the business, not reinvested profits from the business. Okay, so first the minimum investment amount, and then you have to show that you use that investment to create at least 10 US jobs. So it's not just you building the cars yourself, you have to hire 10 other people full-time in the United States.
Yeah, this sounds really interesting. I don't know how they do it. But I know Singapore is a very interesting country that has grown a lot in the last 20 years. So, well, it could be a good idea for you to call. The office is the phone number 216-279-3984, 216-279-3984. You can call the office and they will be pleased to help you out with this request. And why not? You can start a business in the United States, and I would love to go to a place like that because it looks interesting. My VAWA was approved, and I have perm bar. My wife brought me here to the United States and then started abusing me thereafter. I have been married for 18 years and I have US citizen child. Do I need waivers?
Okay, so the question here is, why do you have a permanent bar? All right, so VAWA stands for Violence Against Women Act. That means that you have been abused by a spouse or a parent or one of their sons or daughters. Just because it says Women's Act doesn't mean it's only for women. Men can be abused too. Now, once the VAWA petition, that's the I-360, is approved, the question is, are you eligible to file the I-485? That's the green card application. Permanent bar by itself, there are two ways to get a permanent bar. Number one, if you've been illegally in the United States for more than 1 year, then you left the United States and you came back in illegally, or you got caught coming back in illegally, that's a permanent bar. Okay, so I crossed the border twice. Now, the permanent bar based on crossing the border, being illegally here and coming back illegally, that's not an automatic denial of the green card application. You still could qualify for the green card. Usually you have to show that the reason you left or came back was somehow related to the abuse that you suffered, okay? So just because you have a permanent bar doesn't mean that the green card was denied. Now, if the permanent bar was because you were deported and then you came back illegally, then that's a bigger problem because you have a deportation order and you might not be able to get the green card approved unless you reopen that deportation order. So if it's based only on being illegally here and coming back and forth, then yes, you could possibly get the green card, all right? Now, so if you have the VAWA petition approved, the I-360 approved, the next step would be to file the I-485, but I recommend you talk to a lawyer, to us or to somebody else, to go through the details of that case to make sure that you actually qualify for that I-485. But in general, yes, unlawful presence, permanent bar can be waived by the VAWA petition.
Okay, thank you so much, Attorney Francis. And this person that is writing this question, please don't forget you can call. The phone number is 216-279-3984, 216-279-3984. is the phone number you need to call to make an appointment with one of the attorneys in the law firm. The next question says, I manage a Dunkin'. I am Bangladeshi. Can I bring someone from Bangladesh to help me with my business?
So there's no specific visas for Bangladesh. That means that you would have to sponsor that person either with a temporary work visa or for the green card, permanent residency. Temporary work visas, like we mentioned before, it depends on what type of job is being offered, the Bangladeshi person's education background, experience, and other immigration history, okay? If you want to sponsor for the green card, a US business can sponsor anybody for any position for the green card. We just have to make sure that the person meets the minimum qualifications, that the person qualifies for the job that's being sponsored, okay? Now, for somebody from Bangladesh, the green card process will take between 1.5 to 2 years, so it's not very fast. The temporary work visas we talked about before, there might be a lottery process or some different type of visa. We have to see what kind of job it is, what kind of qualifications this person have to see if they qualify for a temporary work visa.
Okay, thank you so much. And this next question says, can my student visa help me get a green card?
All right, the student visa by itself will not automatically lead to a green card. When you're studying here on a student visa, after you graduate or while you're in school, you can apply for CPT or OPT, work authorization. If you've already able to find a job and that employer is willing to sponsor you for the green card because they like you, they want you to keep working for them, then that employer can start the employer-sponsored green card process. So just because you're on the F1 doesn't mean you automatically get the green card. You still need somebody else to sponsor you, whether it's a family member or an employer or yourself. If you have extraordinary ability, or if you make certain investments. So you still need some separate type of sponsorship.
Okay, thank you very much, Attorney Francis. Well, our time is up for today, but thank you so much, Attorney Francis, for your help, for your answers. We know that people have a lot of questions, but we need to be ready in just in case that we need an attorney. Just write down the phone number 216-279-3984, 216-279-3984. I don't know if I did this question, Attorney Francis. Maybe I skipped it. I don't know if I did it. Did I ask the question of going to Canada to get Venezuelan passport?
No.
No, okay. I lost the question. I know it was here, but I don't know where it is. So it was a person saying, I have TPS. I need to go to Canada to get my Venezuelan passport, but I don't have a passport at the moment. Can I go with the travel permit or travel document and come back safely to the United States?
So you can apply for a travel permit that's called advance parole travel document based on your TPS status. That's on form I-131. The problem is that document gives you travel permission, but it's not a passport. You still need a valid passport to enter the United States. So if you do get the advance parole and you do leave the United States to apply for that Venezuelan passport, you will not be able to re-enter unless you get that passport granted. So you might be stuck in Canada for a while. So it's risky.
Well, I don't know if we need to take the risk. So thank you so much, Attorney Francis, for this answer. I didn't ask that question because I just skipped the question accidentally. So thank you so much for reminding me to ask this question to the person that wrote it down. So Attorney Francis, thank you so much for your time today. I'll see you next time, and thank you for your answers, for your knowledge, and for sharing it with the people that gets joining us in every show.
Of course, you're welcome. Glad to be here.
Thank you so much. And for everybody who has joined us today, don't forget the phone number is 216-279-3984, 216-279-3984. Attorneys in the office of Margaret W. Wong and Associates. They are awesome. They have over 100 years of experience in the office. 46 with the attorney Margaret W. Wong, 10, 12, 15 years for other attorneys, and even other attorneys are like 30 years of experience being judges and prosecutors. They are awesome with what they do. So you need to call the phone number 216-279-3984, 216-279-3984. See you next time. Thank you so much. Have a good lunch and keep in touch with us in the law firm of Margaret W. Wong and Associates.